if you had your top 3 things that could happen to make American justice work better, what would it be?
Well, one thing, we could use a Ministry of Justice, because we need somebody that takes responsibility for the system as a whole, who thinks about having a reasonable system. Now, if you're looking at specifically with respect to the procedures itself, I think we need, what we've recognized before is we need a judge that is more responsive to shaping the issues of the case and more responsible for making the decision at the end and not just throwing it out to somebody else to structure the proceedings. And that's not distant from what our history is.
Right, but that's the opposite. I mean, what both these books have in common is they're calling for judges to make many, many more judgments, to draw lines.
Yes.
Draw lines on how much discovery there is, draw lines on who can sue for what, narrow the issues at the outset.
Let judges be judges, but that requires that the selection process be transparent, be accountable, and accountability is not antithetical to independence. In fact, it's the flip side of the same coin. So that's number one. Number two, teach judges how databases work, because if they don't know that, they get gamed by every lawyer who comes before them under the age of 40. I've seen it happen a trillion times.
What's a database?
It's a rather personal question, Philip. And then last is this culture. I mean, there is this culture. It was interesting. You talked about discovery being perceived as an inquisitorial process. Of course, and you said that here in the States it is. The difference is, and this gets to this sort of excess of sort of rabid democracy, which I understand because I've shared it at times. There's this belief that as long as it's mutually inquisitorial, it's okay, right? So it's adversarial, it's not inquisitorial, but that way madness lies, or paralysis.
In terms of the control is I think also the law is what, we're putting these facts within the law. It's not an opportunity to say what might be right. The law tells us what's right, and we need to fit the facts within those laws.
Right, but you would agree, just on the culture, we have a system that basically assumes you hurl a dispute towards random decision makers, in the case of the jury. You let the adversaries argue almost anything, not completely, but within broad boundaries, seek discovery that's virtually endless, or can be, and then are surprised that it's very hard to ever get to trial or get to a decision, and yet any decision that any system that replaces it involves giving someone authority to make choices about how much is too much, or where you draw the line, which is culturally for our country, I think, perhaps quite difficult.
I agree with all of that, with possibly the exception of the adjectival use of random to describe members of the jury. I have more faith, I think, in the jury system than at least I've inferred from some of your writings. I'm perfectly willing and eager to pilot as many different kinds of specialty courts as we think might lead us to smarter, more efficient, and fairer judgments. But a lot of the academic literature shows that bench trials do not lead in aggregate to radical differences from jury trials.
Right, and what do you think about the culture? Do you think culturally America could accept anything closer to the
I think
to the civil law country?
I mean, I think we can, because I think what is in the civil law country is not very different from what we want, and that is better decisions according to law. And I think we want juries to decide according to law. That's the instructions we give them. As it is now, jury trials are as rare as hippopotamuses in New York, was one of Longbein's remarks, and it's not really the system we have. But we want, if we do use them, we want them to decide according to law.
Right, just because this is on tape, I want to say, I agree that studies show that juries are generally just as wise as judges. The problem with juries is they don't have the authority to render precedent. So 9 out of 10 juries could say that the seesaw is reasonable, but the availability of the multi-million-dollar verdict for the one that doesn't drives the behavior for the reason that Dan Kahneman says. It's the overweighting of low probabilities. And so you have this crazy society where no one will put an arm around a crying child because they're afraid of being accused of being from Penn State. And, or there won't be any jungle gyms or seesaws for the same reason.
Obviously, I completely empathize with that point. And we live in a society, social, economic, political, and legal, where we have, in my opinion, surrendered to the heckler's veto. And it's happening all around us. And the result is, to quote Philip Howard, not to mention Becky Kourlis at Isles, my kids can't play tag at recess. And that is a true fact in Maplewood, New Jersey.